But for many people who have private dispute resolution, they actually end up coming out of a dispute feeling worse than they went into it. Even those who succeeded in disputes may feel it hasn't provided what they really wanted to in taking it to court.
Thank you for watching this video. Please help us keep the show alive by liking and sharing this video and by subscribing to the show and making sure the notification button is switched on. For those of you who can help a little bit more, there's a Patreon link down below where you can contribute whatever you can. Every little does help, and all the money will go directly back into the show. You can also keep up with our latest content on Instagram at The No Show Pod, as you can see on the screen. As you know, The No Show is an initiative designed to make academic research accessible to everyone. So do contribute to the conversation, leave some questions, have a discussion, and I'll make sure I get back to everyone. So Michael, thank you so much for joining me on The No Show. I'm really pleased to have you.
Well, thank you very much for the invitation. It's a pleasure.
I was sort of really interested in speaking with you because seldom do we find academics that make the law, which is by nature to many people boring, seem quite interesting in that you want to sort of you want to change the way we think about law. But before we get into the research, can we just sort of explore your background a little bit? Like what led you down a route of sort of teaching law and being interested in law?
Well, I qualified as a barrister in my 30s after working in education and teaching in the British Council, and very much value that training, the emphasis on objectivity and detachment and integrity. However, when I trained as a barrister, I became concerned that the adversarial process wasn't appropriate for the resolution of many disputes. I think it's absolutely appropriate and really, really important from the point of view of the rule of law that public law matters are adjudicated. But for many people who have private dispute resolution, they actually end up coming out of a dispute feeling worse than they went into it. Even those who succeeded in disputes may feel it hasn't provided what they really wanted to in taking it to court. So after qualifying as a barrister, I worked for a little while in a law centre covering for the supervisory solicitor on maternity leave in Gateshead Law Centre in the northeast of London, serving a very poor community adjacent to Newcastle. And there we were concerned not just with law, but what its public impact as well as what its individual impact was. And then I had a job I thought I'd take a job for a few years, but eventually ended up working for 17 years with the Society of Friends, the Quakers, working as their parliamentary liaison officer, which was about trying to influence the law from a public interest perspective, and very much became interested in dispute resolution, in what are the peaceful processes and ways of resolving disputes. And really then now teaching at SOAS and teaching ADR. After that, I qualified as a mediator in both community mediation, but also family and civil mediation. And then working at SOAS now, I'm teaching public law and I'm primarily teaching alternative dispute resolution. So it's trying to put together some of the learning that I think I had in working with Quakers with their emphasis on dispute resolution, together with the how that plays out in a legal context.
That's very interesting because you have done it on sort of both sides, the practical side and the theoretical side. So the nature of mediation, how does it currently work? How is the system set up in the UK for mediation?
Well, just to take the mystique out of mediation, essentially what it is third-party facilitated negotiation. It's where a third person, not a judge, an arbitrator, or an adjudicator, helps two or more parties to find a resolution to their dispute. But then whether that's community, family, or civil mediation, that really takes place in a legal framework. Some people would say in the shadow of the law.
And so, does the mediator have sort of enforceable power?
No, the mediator doesn't have an enforceable power. The mediator is responsible for the process of resolving that dispute, and the disputants, the parties who would otherwise be litigating or are at a stage of litigation, they have responsibility for the substance, and it's up to them to agree whether or not there is a settlement to that dispute. Sometimes, as in community mediation, there won't be lawyers involved at all. Sometimes, as in civil mediation, the majority of civil mediation cases, the parties will be there along with their lawyers. And in the case of family mediation, mediating the end of often mediating a divorce settlement coming out of a marriage, the parties generally won't be there with their lawyers, but it will be a process that takes place over a number of days or numbers of weeks. And between each stages, the parties will go back to their lawyers to take legal advice. And the eventual outcome of that family mediation then will become an order of the court, albeit a consent order. So it very much depends on what the context is in which mediations is occurring.
And so you predominantly did family and community, as I understand.
I've trained as a family mediator, but done very little family mediation. I've done most community mediation, but have also mediated some civil disputes with CEDA or with clerks from.
And what are the sort of typical community disputes that exist there, or some of the disputes that examples of disputes that you've mediated and been involved in?
Well, it very much depends on the context and the area. I actually first trained as a community mediator at the same time as trained to be a barrister when I was living in Lambeth with Lambeth Mediation, a rather wonderful mediation service, which grew originally in the aftermath of the Brixton riots. An inspirational couple set it up, Victor and Greta Brooks, with many other people from the community, and that was really largely dealing with disputes among neighbours. And it could be about noise, it could be about smells, it could be about children. It really is broad as the problems that you get in a community. But what was interesting is when you drilled down, many of the disputes that were apparently about noisy neighbours, for instance, actually reflected the underlying social problems of poorly built houses in the interwar years. So what presented as a problem between two neighbours might equally be a problem of poor quality housing. More recently, I've been a trustee and a mediator with Mediation Hertfordshire, where I live now, and you have some of the same problems, but also different problems about parking, leylandii, hedges, maintenance of boundary disputes, so maintenance of fences. It can depend so much, and then within those, you can also have presenting as community mediation problems. You can have intergenerational disputes, and some of the disputes we've dealt with in Mediation Hertfordshire have been schools cases, fascinating cases that have arisen out of disputes that have originally presented themselves at the gates of schools where children are attending.
It sounds incredibly diverse. But what's to me is really interesting is that it, in many ways, I come from Iraq, and Iraq, you have the tribal mediators that get involved in this sort of stuff. And it's similar in some ways, in that it's mediating and it's bringing, and it's community based. But then the difference is, I understand how things are enforced in Iraq. However, in the UK, when it comes to sort of community cases, and supposing you're the mediator of you know, some dispute between a school or between neighbors. How do you sort of get to a resolution? Do both parties have to be sort of 100% convinced that this is the right solution?
I think I wouldn't propose a solution. The solution has to come from them. Parties have to be willing, I think, to compromise, and have to be willing at least to give it a try. Sometimes you can't find a resolution to a problem, but doesn't mean to say that it's been a waste of time coming to mediation, because it may have clarified what the problem is. It may have clarified where legal advice is needed. One aspect of community mediation, as the way it's developed in this country, which is, I think, different from some of its antecedents. I mean, classically, people look to examples of community mediation, such as panchayats that have happened in India, or Norwegian village moots. But the values of community mediation, we do set out a framework of the importance of courtesy and respect and regard for equality. So, for instance, if parties coming to a mediation were either showing sexist or racist behavior, or were showing behavior that was disrespectful to someone whose sexuality they didn't approve of, we would have established in the ground rules that whatever their personal feelings, they needed to put those aside and be willing to respect the other person who was involved in mediation. So there is a framework which takes place to it. And in that sense, I think it is socially normative. It's also socially normative in that, where possible, and I think community mediation is at its strongest, where the mediators are drawn from the community in which the mediation is taking place, or a substantial number of mediators are drawn from the community. And that was very much the idea behind Lambeth Mediation Service.
That makes sense in many ways. But I want to just play devil's advocate for a second. Supposing that you've set out this framework and a party that's involved in a dispute chooses not to stick to the rules of this framework, what happens to them?
Yeah. Well, initially, you would draw their attention to the fact that they've breached the rules, and eventually, and this is the strength of having them as ground rules, when you come to mediation, if they really didn't agree with those, you might have to withdraw from a mediation. But withdrawing from mediation isn't something you want to do, because then the party who's often asked for the case to be mediated is left without a remedy, is left without a resolution. But certainly, I've been involved in mediations that have got either such a pitch of aggression that it's been necessary to call a break, or where it's quite clear that some of the underlying attitudes are such that you would never reach a resolution. I think what's interesting, when I started mediating, I had quite a driven attitude to getting a resolution. I think I felt a personal failure if I didn't get a resolution. Mm-hmm. More recently, I recognized, and largely through mediating with others, that actually can be something very, very powerful to remind the parties in a mediation, look, this is a voluntary process. This doesn't seem to be going anywhere. I don't want to waste your time. I hope you don't want to waste my time. If we're really not going to get anywhere, perhaps it's time to draw a halt to the mediation. And it's sometimes at that point that parties then become willing to compromise, because they'll consider, look, I may not like meeting this person, for instance, where you've got intense animosity between two neighbors. I may even be afraid of them, but it's much better trying to deal with these things in a room with you and often another person present, rather than bumping into them on the corridor of a shared area of a block of flats when they may have come out of the pub at 10 o'clock, or where they may be in an aggressive state of mind.
So what lesson, I mean, being a mediator, fundamentally to me sounds like it provides you with one of the most important sort of life skills for relationships and just society in general. So drawing from your experience in that, what sort of lessons can you pass on to, our listeners, about how to go about sort of resolving a dispute?
I'm not sure I have anything that I can offer in terms of lessons like that. But what is wonderful is seeing a group of students coming together at the beginning of a year and during or at the beginning of a term, and by doing role plays and simulations, really seeing the way that their life skills change. I think a part of that is seeing that when you come into a mediation, it's as important to listen and be listened to as it is to speak. I think it's about trying to understand the difference also between the positions that a party adopts in a dispute and what their underlying interests are. And then maybe even more than that, more than their interests, and you can sometimes tease this out in a longer mediation. What are the values that inform those? What are the values that inform those interests? I think certainly there's also psychological skills involved. I mean, the kind of skills of a mediator, I think, are really those, as well as being able to listen or actively listen in a way which shows you've understood. The single criteria of nothing is more important than empathy.
Absolutely, and that's sort of vital to. I guess it's vital to any skill. Talk to us a little bit about mandatory mediation, the paper that you wrote, or the research that you've done. What is that? What was the purpose of that?
Mediation has become, particularly in terms of civil mediation, a bit of an industry. It's become a bit of an industry because, as well as a pressure from below, of people wanting to mediate from the point of view of wanting access to justice, and a kind of a sense from among people involved within the legal community and those concerned with disputing, sense there's a better way of doing it. There's also been a sense from above, if you like. For example, the reforms by Lord Justice Wolfe to the civil justice system, the desire to change what was a culture within the legal system of late settlement. And part of that has been encouraging mediation, but there are those within the, if I can use the expression, the civil mediation industry, who say, look, not only is mediation a good process, but it's a process that's not sufficiently well known. And the way to get it better known is for mandatory mediation, for everyone to have to try to mediate before a case is brought to court. And what I've been trying to consider is not only what are the advantages of mediation, but what are some of the disadvantages of making it a mandatory process, of making it compulsory, whether directly compulsory in terms of a gateway to the legal system, a requirement that you show you've tried to mediate, or impliedly compulsory because you have costs, penalties for not mediating that are so weighty that in practice people have to try mediation first.
So what is the main drawback of making mediation mandatory?
Firstly, mediation is a voluntary process. It depends upon its voluntariness, and it depends upon parties being willing to negotiate and willing to understand each other's points of view. And even if they can't actually empathize, at least having a kind of cognitive empathy of being able to try to put themselves in the shoes of the person that they're negotiating with. Now, if you have mediation as being mandatory, it then means to say, to what extent have you got that voluntariness on which mediation depends? Secondly, it's the cost involved when you are dealing with an someone who is really unwilling to negotiate. Take, for instance, supposing, to take an example I was thinking about recently, a person providing piano lessons has had a late cancellation before their first piano lesson. Their contract provides that in the case of late cancellations, that the person who is going to have that piano lesson is responsible for paying for the whole course of piano lessons. The person who's cancelled late thinks that's unreasonable, I shouldn't have to pay for that. Actually, in that case, the law is very clear. Where there's a contract, they have to fulfill that contract. Now, if there's mandatory mediation, that provides an extra cost for the person in essence who's trying to recover their debt. And why should they have to do that? Because someone is behaving unreasonably. I'm giving you an example, I probably think of a better one. And it's, or in cases for a recovery of a debt, really what someone wants is the recovery of that debt if it's a legitimate debt. And mediation can then be used by an unreasonable litigant to prolong a process, and to make it more difficult to recover the sum that's legitimately owned. And I think that's where it begins to undermine access to justice, and by implication, begins to undermine the rule of law. There are other more complex cases, but no less important in family law, for instance. There is an assumption in family law now that before divorcing, you should try to resolve the settlement before going to court in a contested divorce, you should try to resolve the issues between you by mediation. And all very well, but should, for instance, a woman, although it could be a man, who has been subject to domestic abuse, should they be forced to face the person who they're divorcing because of that in a mediation? And I think in that case, actually, the law recognizes they shouldn't. But it's a range of cases where there may be personal reasons why someone would not want to mediate, would not want to negotiate with the person who is the subject of their litigation.
So ultimately, all mandatory mediation does is just forces two people to come together and essentially make them incur costs. Is it possible to be done without these additional costs?
It isn't possible to be done without costs unless you have mediators who are prepared to work on a wholly pro bono basis, which isn't the case at the moment. What's happened in the civil justice system at the moment, and there's a case of Halsey and Milton Keynes NHS, which is authority for that, is that an unreasonable refusal to participate in mediation can itself be seen as unreasonable within the litigation process, and as a result of that, not taking part in a mediation can lead to costs penalties, and that's broadly where the law is at the moment in terms of cost recovery.
So it kind of, I mean, to put it in more simpler terms, it sort of makes that party look a bit guilty.
It makes them suffer consequences as a result of not engaging with the process of mediation. And where there are, I mean, in terms of the law at the moment, there may be cases where a party considers it has an open and shut case and therefore doesn't want to mediate, and it may be reasonable not to mediate in those instances. But what isn't reasonable is a refusal to engage with the process in terms of saying why that you're not to mediate.
And so how does that tie into the rule of law?
It ties into the rule of law in that, well, the aspect of mandatory mediation that I'm particularly critical of is where you get court-annexed mediation with a degree of compulsion that you don't presently have in the English legal system. And what I'm saying is that would, which is what some mediators are advocating, that would undermine the rule of law in terms of impeding access to courts. But it would also potentially undermine the rule of law in another way, in that the law depends upon the development of precedent, and it depends upon there being an adequate number of cases which come for adjudication on which precedent can be created. If you don't get those precedent-bearing cases, then you don't have the guidance of the law, and that may paradoxically make dispute resolution more expensive rather than less expensive if you haven't got those clear legal guidelines.
That I can see, so I can understand how that happens or how that works. And so, generally speaking, now, do you feel that there are strong enough calls to make mediation compulsory?
I don't think mediation will become compulsory in a sense of there being a legal fine or punishment for not mediating. I think increasingly there will be costs penalties for not mediating. And I think it will increasingly becoming part of the civil justice system. So rather than being alternative dispute resolution, it's actually more becoming embedded within the system, a complementary form which takes place within the legal system. And I think the danger of that is that mediation is insufficiently regulated, and there is then pressure for mediators to adopt a style of mediation which is not really about facilitation, but is more about evaluation. And then potentially people taking part in mediation aren't really clear about the process they're signing up to, and may feel a pressure to settle, which actually isn't there. So if I were thinking about what should be mandatory within mediation, I think mediators should have to tell the parties, if you want to leave this process at any time, you can. And although that's the kind of where we are in terms of the law, I think many mediators don't adequately say that, and therefore parties can feel a pressure to settle. Okay. Not legally represented parties, but non-legally represented parties.
Where can people find you online or explore a bit more about the work that you do?
They can look at my page on SOAS, and perhaps more importantly, if people want to mediate disputes, they can look and see if there's a local community mediation body they can go to. In terms of if people have disputes in family law, they can try and find family mediators, for instance, looking at mediators who are provided under the auspices of the family mediation, the FMA, the Family Mediation Association, and they can look at the regulated mediators under the Civil Mediation Council if they want to, if there's a dispute where they feel civil mediation is appropriate. What I think I maybe haven't in our conversation with you, I haven't adequately brought out, is I am not critical of mediation. I think mediation can be a wonderful process. It really can resolve issues and put what's central to the parties, what is dealt with in the negotiation, rather than how a judge decides a case. But I think that requires psychologically skillful, facilitated mediation, rather than the shortcut of a more evaluative style, which is what you tend to get in court mandated programs.
Excellent. Michael, thank you so much for taking the time to join me and sort of enlighten me on this whole process. It's something that I feel like not enough people know about, and it just sort of catches them by surprise when a situation arises, whether it's in their personal life or just in their everyday civil life. So I think it's a wonderful opportunity to be able to explore that and for people to hear it.
Well, thank you so much for the opportunity of the conversation, and I'm also fascinated. I'd love it another point to have an opportunity to understand more about mediation in Iraq. It sounds absolutely fascinating.
Absolutely, definitely. I would love to have you on sometime soon, and we can explore that too. Thank you for watching this video. Please help us keep the show alive by liking and sharing this video, and by subscribing to the show and making sure the notification button is switched on. For those of you who can help a little bit more, there's a Patreon link down below where you can contribute whatever you can. Every little does help, and all the money will go directly back into the show. You can also keep up with our latest content on Instagram at The No Show Pod, as you can see on the screen. As you know, The No Show is an initiative designed to make academic research accessible to everyone. So do contribute to the conversation, leave some questions, have a discussion, and I'll make sure I get back to everyone.